Every October, another term for the U.S. Supreme Court begins. Hearing arguments that have been granted access to the nation's highest court, this October is no exception. But 20 years ago this October, the Supreme Court heard a precedent-setting lawsuit that had wide impact on consumer safety and whether or not plaintiffs could use testimony of former manufacturers' employees in lawsuits against companies that made defective products.
This was our Kent and I's first large case, and so this was we were a small law firm.
Bob Langdon is an attorney at Langdon and Emerson in Missouri.
It was a case that really helps our system of justice. I mean, you can't silence people who want to tell the truth and get out the truth about practices of corporations that are trying to hide things from the public and hide defects from the public.
In the original accident, the plaintiff was caught inside of a burning car, which her attorney argued was defective.
This was a case that involved a car crossing the center line and hitting the vehicle my clients were in, and it immediately burst into flames. There was a gentleman traveling from Iowa, truck driver, who jumped out and went to the scene and tried to get our clients out. The driver was killed on impact, and our client was in the passenger side and was still alive and was screaming to try to get out of the vehicle. And while he made every effort possible to get her out, he was unable to do so, and she burnt to death in the vehicle. It was very tragic, with two young boys who at that time were hit me about my waist. And by the time the trial got over, 10 plus years later, they were both taller than I was. So, but two great young men who lost their mother. This case was about, in this time frame, we have to remember, fire cases where people were burnt to death in cars were very common. There were a lot of reasons for it, but they were very common. And when you think about gasoline, people don't realize, but a gallon of gasoline has the energy equivalent of 8 sticks of dynamite. And so when you carry liquid dynamite around, you need to make sure that the container is safe and is protected. And this really wasn't a concern of the automobile manufacturers. So we had many fire cases, horrible deaths and horrible injuries that just really affected families in an adverse way. And so as we started taking on the industry and saying, you've got to route things in a safe way, which they didn't do in Baker. You've got to make your tanks safe. You've got to make your check valves safe. You've got to make these changes because people are getting burned to death or burnt horribly.
In the mid-90s, the plaintiff's legal team had identified testimony from a GM engineer that pointed toward liability for the manufacturer. Whether or not they would be allowed to use that testimony was a central part of the Supreme Court argument.
Elwell, who was the main character that involved, he was a former employee that General Motors had got an injunction in Michigan to keep him from testifying. Our judge let him testify anyway in our case, and they appealed that to the Supreme Court. And this is the first time he testified, and his testimony was that they told him he could only use $1.50 to fix the system, that they couldn't use any more than that to fix the fuel system, that they found problems. And so they didn't fix the line that was run in the wrong direction. And when you had a frontal, that the parts of the engine would come back and cut that line.
Langdon's partner, Kent Emerson, had this to say about the case before the Supreme Court argument.
If General Motors succeeds in precluding Mr. Elwell's testimony in this case, it's going to provide a blueprint to all the other corporations as to how to keep current and former employees silent by paying them whatever amount of money is necessary to do that.
Without the verdict in Baker versus GM, manufacturers across the country of defective products could have virtual immunity from having to be liable for first-hand testimony from their former employees. To argue this high-stakes trial before the nation's high court, this group of personal injury attorneys from Missouri reached out to famed Harvard law professor Lawrence Tribe. While GM hired Kenneth Starr for the Supreme Court argument, the famous corporate lawyer wound up bowing out of the argument due to conflicts at the time with Whitewater.
So they had a young man who argued in front of the Supreme Court, and you could tell by the questions that Justice Ginsburg was the hot judge, and she continued to press this young man on why Michigan should be able to do this, and his answers weren't very to her liking. And her last comment to him was, well, sir, if we rule for you, Michigan rules the world. And at that point, I felt like we had a really good shot of winning, and we did win 9-0.
After receiving a 9-0 Supreme Court verdict for the plaintiff, fast forward 20 years to today, and the same law firm is now handling a number of claims involving defective guardrails and other products. Today, Baker versus General Motors is still studied in law schools as an example of how plaintiffs are now allowed to use expert testimony from former employees and whistleblowers that might not have been allowed in a courtroom had this decision gone another way.
If you can shut everybody off by just getting an injunction out of a state to say you can't ever testify anywhere else in any other court, then the truth about these defective products would never come out.